Your Honor, Min Kim on behalf of Mr. Dwyer, as well as all of the other neighbors.
Good morning, Your Honor. Deputy Gordon Lien here on behalf of.
All right. Where are we on these matters? Can I dismiss them and get them off my caseload?
We're okay with that. At this point, we, as we indicated last time before you, Judge, everybody that was on the docket has been no longer in a hotel. Everybody's been moved. Everybody's been relocated on their own or moved to alternate housing. So there's no longer an issue with any of those tenants. The property's actively undergoing remediation. We've still got the two buildings, 720, 721 West Clark, 720 Green. They are ready. We are still waiting for city to allow us to have our COCs. Everything on the COC list has been done with the exception of 2 things that the city is requiring Arbor One to do, which is still air quality testing, which we are before Judge Simpson dealing with that. They are also requiring us to place baseboard covers that are fully functioning, but for cosmetic reasons. And there's also an issue of remediation of 4 small areas in the unit that did not pass the spill test. Those are the only things remaining in these buildings. We would, at this point, there are no health and safety issues from the property management team's perspective. So there's no reason these units should not be occupied, but the city is pushing back on that. So we have not gotten COCs yet. They've started the process on the next 3 buildings, 1431 LaForge, 1433 LaForge, and 772 Green. So they're working on those. Property management team says timeline from when we started should be 7 to 8 weeks. Could be less, half the time and half the money without the requirements the city is placing on us, but we work with what we're given. So they're actively working and they're moving down the list to the next buildings. So things are ongoing.
No. All right. So go, Ms. Kim.
Your Honor.
Yeah, go ahead.
I don't think it's correct that all the tenants have been relocated. I know that, for instance, Mr. McGuire is still looking for other housing. And I'm sure the court is aware of Judge Simpson's partial preliminary injunction, allowing the tenants some options to relocate.
But yeah, and I don't mean to interrupt you. Is that where there was the agreement that the tenant would sign that they would leave and then?
Correct.
Okay.
And I believe we had last had some emails with Ann about what the court required for the release of escrow, whether they can just submit the move out agreement, the court order move out agreement, or whether they had to file a motion with the court.
And I don't know I don't know how Ms. Wadling responded, or did we respond to you on that?
I think that you were waiting for a copy of the order. And
right, because I think that was right before a hearing. But so there was one case, I'm good. There was one case where what we did is the tenant came up, provided the agreement to us. It was signed off both by, I think, Beal and by the tenant. I read the agreement. The agreement made sense as to what it was saying. And so then I issued an order releasing the escrow pursuant to the agreement and attached it.
Correct.
That is how I thought all of the other ones that were going to happen that did that would take place.
So they do not need a motion. They just need to.
I don't, somehow or another, it has to be. They don't really need, I mean, I hate to go through the whole process of filing motions on it because it is rather straightforward. Just so you know, the young lady that did the other one, she brought it up to the court. Clerk didn't know what to do with it. Got it to us. I read it and then I did the order. Okay, because I understood what was going on. Would I need a formalized motion? No, but would I need some way to recognize that we're receiving it? Because if it's what that person did, I'm gonna issue the same order. I mean, it's not like we've got to reinvent the rule.
Tenants and the tenants union about what the court needs with that document. If there's anything additional.
No, but I just have to have something that says I'm submitting this stuff. You see what I mean? I mean, I can't just have loose paper flowing
Like
in.
a cover letter, you're saying?
Yeah, that's fine. And just direct it, or if you know the tenants, they could just send, you guys could send us an email asking us to issue an order releasing the escrow. Okay.
And,
I just want to make it as simple as we can.
and I just wanted to add to, Sister Council's summary that, I just got an update from, one of the city's attorneys this morning about the process of the administrative reviews, where those are. And apparently Arbor One lost the appeal to the County Board of Review, Construction Review. And also, I guess the other appeal before Judge Conkey is still pending. And at the hearing on Friday, there was testimony taken about the air quality testing, and that evidentiary hearing is continuing on July 10th, I believe, at 9 a.m. And there was some discussion about whether there should be a neutral, not neutral, but I mean a outside third-party inspector involved in all of this. And a conservator was appointed last week. An order is about to issue soon. I think those are the additional updates that I can think of. There is one other concern, Your Honor. A lot of the people that were relocated by Arbor One to the villa side, are you aware?
Go ahead. I'm listening.
They're paying money into escrow as this court requested, and they're being sued for eviction in 14B.
Correct.
And we are representing a couple of them, but it's a big concern.
I had talked to Judge Washington about that, right? Because now these cases are flowing over into various jurisdictions. Certainly, I think that those issues could be resolved in one of two ways. One would be to file with this court an order to either transfer, if all the issues are resolved, we would just pay out what's in our escrow to the landlord.
Resolve
Okay.
that way.
I mean, if the case so if the tenant's suing the landlord, the new landlord, and that's in the 14B jurisdiction, the villas, and all the issues are resolved, it's just an issue of money, then in order to this court saying that can be paid to the villas, I would sign off on something like that. If the issue is that there's going to be some litigation surrounding that, then it would seem to me to submit an order just requesting that this court transfer the escrow to the 14B district court on whatever that case number is.
I'm not quite following, Judge. So these are non-payment eviction cases where the tenants are paying their rent into court escrow here. So
Correct.
you're saying you want the escrow just transferred to 14B?
Well, there's going to be one or two things that are going to happen with the escrow. Well, I guess there's a third option. Either the escrow is going to be subject to the order that Judge Conkey issued regarding the distribution of that, because that person has technically given up their other unit. So under that order, it may have to go to the tenant.
So under Judge Conkey's order, if you have asked Arbor One to temporarily relocate you, then
It's
you're not getting
50%.
a refund of the monies right now.
I thought it, as I read it, it was 50%.
They're supposed to be paying, if you're asking for temporary relocation with the intent of coming back to
Right.
Harbor One, when you place in a unit that has a COC, or when your unit gets a COC, whatever that winds up being, they should be paying 50% of their rent from wherever they're relocated to.
Right.
If they're being relocated permanently with no intent of coming back to Arbor Run, and they're being relocated to a place that has a COC, there's no reason why folks should not be paying rent in a unit that has a COC. Judge Kunke's order is very clear that rent is only abated if there's no COC. So if these folks are intending on staying wherever they are, they should be paying full rent to Arbor One. And I will say, Your Honor, we are not handling the township side, so I can't speak to any of the actual.
Of course not,
cases that have been
right?
filed. But I would presume that if they're not paying the rent to the landlord and they're intending on staying there
Okay.
long term, that's why the eviction is filed.
And
disagree
right,
with-
that, go ahead.
I disagree with what, first of all, there's nothing in Judge Kunke's order about paying 50% of.
Oh, no,
Yeah.
that's the way I read it. The agreement was that if they were voluntarily surrendering the unit without an intention of coming back, they would get all, for our purposes here at 14A, they would get all of their escrow. Right?
If they're giving up and not coming back.
If they're giving up and not coming back. The part I didn't know what to do with, because my understanding was there's this 50% split, is that if they went someplace else, I don't know what to do. There has to be an order or something submitted to the court as to what to do with that escrow. Because my understanding is there was this 50%, which I didn't understand, but it wasn't my order. There was the 50% split to, let me see if it's in this
There
tenant.
was some discussion, Judge, about the 50% because tenants who are placed in hotels had no way to cook their food, etc. But I don't think that language made it into the order.
It's not in the optional move-out agreement. I can tell you that much.
Judge Kunke was very clear on the record that her intent was to have residents who are requesting to be temporarily relocated pay 50%. She very clearly asked legal services, Blue, I believe specifically, whether or not she would rather not include anything in the order with regards to temporary relocation and kind of let it be what it may, or consider or order that tenants pay 50% of their rent and make that decision.
It might have just been an oversight, but it's not in the order. But I would have to say that I believe the tenants
I don't know that
are paying, actually, I think they were paying their full rent into the court escrow here.
correct, because we didn't, because the allegation that was raised was that they were being relocated by Arbor One to the villas in the township. There were issues that were raised as to the fitness of those units. Okay, I don't know anything about that. Those aren't my cases. So the tenant asked me, what should I do? I said, well, we have the escrow open. At that point, there's no case at 14B. I'm aware of that. So I said, just continue to pay your rent here with the thought process that could be that the financial pieces could be straightened out rather simply by virtue of an order. If they were sued in 14B and there's an issue, I don't know why you couldn't submit an order to the court just asking us to pay those funds over to escrow in 14B.
So from what I understand, Judge, the tenants that have been relocated to the villas, some may have signed leases to stay there permanently, but the tenants that we're representing, they're there temporarily until their units get their certificate of occupancy. They're in small
Okay, that's
units
fine.
They want to be, or their conditions aren't right, or for instance, there's another tenant who's,
Well, what are you asking me to do though?
I'm not sure what the right thing is, Your Honor. I don't know if 14B should have jurisdiction over those cases in a non-payment case when they have been paying rent. There shouldn't be a non-payment eviction filed at all.
And that may be, I agree with you in the sense that that may be your defense to their claim. When they filed the case in 14B, your defense of that is they've been paying their rent all along. Right? It just happens to be here because they got relocated there. So the way to resolve that, it seems to me, is in one of two ways. If those folks are going to be coming back, would be to take the escrow I have here, get an order to send it to 14B to be held as escrow on that case. That would seem to me to be the simplest thing, and then that has to be litigated over at 14B.
And then what would happen to their case here? Would it be stayed?
Why would I stay that?
I mean, they have counterclaims. It's not just about the rent being paid, as you know. Just these people that Arbor One did not have the right to collect rent since September 17th.
Correct.
So in some
So
aspect, they should just get the escrow released to the tenants.
I don't have a problem even if you do the math with that concept of it coming back to the tenants, if that's what Judge Kunke ruled. I don't have a problem in that. But there's a point at which they're now in the township. Right? They moved. And I don't know that these folks, but you're saying these are not folks that have signed leases. These are people that are just temporarily housed there and are coming back. So let me think about that a second. It would seem to me that those folks that are temporarily housed there and are coming back, that I would release or do whatever with that escrow consistent with whatever Judge Kunke's ruling is.
Judge Kunke's ruling and the move-out agreement with regards to the release of escrow are specific to the folks who are entering into this move-out agreement. These folks that Sister Counsel is talking about are not subject to move-out agreements. There's three options that folks can select. They can select the move-out agreement,
Right.
break their lease, and they receive a
gone.
refund. They're gone. They're finding their own housing. They're leaving. They're doing that. Folks can choose to stay in their units because, quite frankly, a lot of these units have been turned and are perfectly fine, and they are just choosing to stay. Or folks have the option.
And let me ask that. So if they stay, they pay rent? Or
People who are staying are
Whatever.
electing not to pay rent. There are folks who are voluntarily paying rent because they have some sort of other obligations that they recognize, whether it be some sort of assistance or just recognize.
Whatever. Okay.
Or at least. So, or there are folks who can elect to be temporarily relocated by Arbor One, and with the intent of coming back when they get placed in a COC, a unit with a COC, or their unit gets a COC. So the release of the escrow portion of the move-out agreement is only for those folks who are entering into those move-out agreements. There's been no discussion about release of escrow or anything of that nature with regards to any of the people who are electing the second two options. So I'm not sure why we're talking about escrow with regards to the folks who are temporarily relocated, because they're not even subject to that issue.
Well, right. And so
I don't disagree with what she's saying, Your Honor, but I think that transferring the escrow to 14B means that Judge Washington will be hearing all of the same issues that this court is hearing, and it doesn't.
welcome to the wonderful way we've set our courts up.
I think that, I mean, I might have to confer with my team, but I think that the 14B cases should probably be dismissed because they are not really not paying their rent.
Well, and I may, for those that have not signed a lease. So if they move over into 14B, sign a lease, then, and they have escrow here, then this move out agreement is what would apply. Right? Because they permanently relocated, they said, I'm not coming back. If they moved over and it's a temporary housing until there's a CO, I don't even know how a case is being filed against them.
That's what we're saying, Judge.
But that's not, but hang on a second. That's not my call to make. I mean, if it were before me under the circumstances, I could tell you what I'd do, but Judge Washington may have a different view of it. And that is, I'd say, well, they're coming over here because their unit is not what it is. So I don't know why you're here asking for non-payment. Because really everybody's just hanging on to these cases because your unit isn't up to date.
And
That, I mean,
there are motions that are going to be heard on July 9th on this issue with Judge Washington.
so you guys have managed to get at least 3 judges involved.
I'd rather just do one forum, Judge, and I'm renewing our request to stay all of it.
These cases?
Yes.
Well, I think what I'll do is I'm just going to give another date because so let me just throw something else out there so that everybody knows also why my life becomes difficult. There are tenants who are Arbor One tenants who have relocated to other complexes outside of the villas that are within my jurisdiction, who are now also before this court by their new landlord for not paying rent. It seems that the landlords and the tenants are aware of their circumstance. But I don't know what posture is being taken with regard to the new landlords. And some of these new I think the ones that I just heard, I think they're all BO properties.
Okay.
But I don't know under what circumstance. There were, I think, 2 individuals this last docket. I don't know under what circumstances they went. So I don't know if they went and it was a temporary thing and then they were going back.
Anybody that was relocated outside of the villas was not, my understanding, though, the only temporary relocations that have occurred have been to the villas. I don't believe that anybody.
I don't think that's correct. There was a order, Judge, where you said any BO properties portfolio, properties available in their portfolio that they were transferring them to as well.
Well, I don't know that I mentioned anything about BO properties. The only thing I mentioned was the villas because I knew they were going across the street to the villas.
But BO properties opened up their portfolio to the tenants who want.
Yes, I recalled that happening.
And those folks have been signing leases, is my understanding. So those have not been temporary relocations.
I think that.
And see, here's my problem. I hear what you're saying. I don't know that.
Another wrinkle, Your Honor, I think that tenants who signed leases may have felt like they had no other option if they wanted to stay in that new property. If you recall,
I remember.
Gil was making them pay application fees and new security deposits and having them sign leases. And I don't know if the tenants were aware that they could refuse to do so. If you have the name
I had 160 cases. I don't remember those 2. You do? Okay, well, then we can get those to you. But I don't know what the status of them is. And now I have this other landlord involved, but I don't. So I'm not sure. what to do with those, and I'm not sure how many there are out there. But it would seem to me what council's indicated makes sense, that if they're in these other places, they may have signed a lease. And I'll tell you, Ms. Kim, that's what I assumed until you said what you said this morning about the people in the villas getting sued. And they didn't really sign a lease. So,
We have to contact these tenants and, if they're a client with us, and see what's going on.
right. So on these cases, what do you guys want me to do? Because
Judge, honestly, we would request to stay until there's a decision by the circuit court on, whether, when they get a certificate, they determine how much rent they owe, if any.
well, hold it, but this is what makes this so bad. Once the circuit court gets done, and maybe I'm wrong, I'm presuming that they're going to go through for those tenants that dispute as to what rent is owed. There's all that stuff coming back here. Because if it is, oh boy.
Ideally, Judge, would be a overall settlement so that you don't have to, look at every single individual case, and there'd be a global decision.
I mean, we see no reason to
From your lips to God's ear, but I don't know.
continue to keep these cases. I think there's obviously a question of money being held in escrow and what's happening with that, but outside of that, I think
these cases run their course, we should dismiss them.
Well, I get that, but you also maintained that from the beginning. But
I could say,
exactly. But what I'm hearing from Ms. Kim is there would be basically a general objection to that because there may be claims. But
There are some cases of counterclaims. Your Honor.
Yes, there are.
The proper thing would be at some point to remove them to circuit court. And we can certainly continue this conversation between us, amongst us, about whether we should just dismiss all of these. But at the moment, we would ask that they be stayed.
Well, in part of my problem is this. I can't dismiss all of them because I don't have a disposition of the escrow. I
guess I was under the impression that Judge Cook, taking jurisdiction of the escrow.
don't know that.
I mean, I think at this point, the only reference to escrow was in the move-out agreement. There's been no other discussion or disposition of the escrow other than them being able to apply to this court, or if they're subject to a move-out agreement, for court to determine whether or not to release their escrow.
Right.
And we've had one of those requests so far. And
Are you
obviously,
talking Ms. Gamble?
yes.
Yes.
What you entered the order for. And then I believe there's another motion later today, but she's not subject to the move-out agreement as she moved out prior to any order was entered. So that's a totally different situation and request. And so from our position with regards to the escrow, and you'll hear this later, the escrow should be released to be accessible to the landlord for remediation by statute. Your Honor already got it correct by ordering these tenants to put the money in escrow. And so, you've been taking the position that we have to determine what's going to happen, and that will happen at a, later date. We're maintaining that this property is actively undergoing remediation. Statute is very clear that says if there's no CFC, tenant should be paying into escrow, and that money should be used for the purpose of remediation.
It can be. Right.
Yeah, and so that's, if we're getting to dismissing these cases and dealing with the escrow, that's, what the escrow should be used for in our position, so.
But I don't know, and maybe or maybe not agree with you on that. I don't know what tenants are still there.
And that would impact whether or not the escrow was released for remediation purposes or,
Right, so frankly, I don't have enough information because I don't have the whole case. So I don't have, I may have a tenant that has escrow in here. I'm unclear what to do with it because I don't know, should this tenant be subject to the move out agreement? Have they voluntarily done whatever? Are they just temporarily there, either by virtue of Arbor One putting them there, or did they kind of voluntarily move themselves temporarily and they're intending on coming? I don't know. And I think those things, the escrow, what to do with the escrow becomes different as to what to do with the escrow just on those scenarios, and I'm sure there can be more. But Mr. Friedman, if you're saying Judge Kunke took jurisdiction of the escrow, I'll send it all up to her. I'll be good.
I'm not sure she did, I'm not sure she did. Frankly, to be blunt, some of it's kind of confusing because she's saying it can be used for this and she, in a sense, she took jurisdiction over the escrow because she said what it can be used. She said that it can be used for certain purposes. So,
You mean in terms of remediation of the
so
unit?
I believe Mr. Friedman's referring to the terms of the move out agreement.
Got it. Yeah, so I don't have any problem once I saw the move out agreement, like I said on the Miss Gamble, I don't have any problem dealing with it, how I dealt with it, of just issuing the order once I had the signed agreement and we attached that to it. Didn't have a problem with that. That's the only case I've got.
Yes, Judge. There are people I'm sure moved out before the order was issued and
Before which order?
Judge Kunke's order. And unfortunately, those tenants, they can't access the benefit of that agreement. Maybe we could can I propose if we?
Oh, because
They moved out prior to, the move out agreement is specifically for folks who are currently at Arbor One, who wish to break their lease and leave to find their own alternative housing. And so if somebody's vacated months and months before, they can't now come back and say, oh, I now want to enter into a move out. They've already moved. It's a move out agreement for folks who have not moved and are still at Arbor One. So there are folks who have already been relocated or who have already decided to leave on their own. And so
This is a housing court hearing addressing issues between tenants and the landlord of the Arbor One apartment complex. Due to safety violations in several buildings, tenants were relocated. Work on some buildings is now largely complete, but the city has still not issued the required occupancy certificates. Tenants who were relocated to another property, the villas, are now facing eviction cases there for non-payment, even though they were already depositing rent into court escrow. This has created confusion over jurisdiction and responsibility. The court is currently holding two separate funds, tenant escrow, totaling around $20,000, and a separate $62,000 from the landlord, which was meant to cover city inspection fees but was refused by the city. The judge has ordered both parties to submit a detailed breakdown within 10 days so the funds can be properly allocated. The next hearing is scheduled for Tuesday, August 12th at 9 a.m.